Those are acts taken pursuant to a president's authority, but authority that is also shared with the United States Congress.
Senator Kennedy, ranking member of the court subcommittee, for his opening statement. Senator Kennedy.
Thank you, Mr. Chairman, and thanks to all our panelists today.
Thanks.
With respect, I don't agree with the way our esteemed chairman has characterized this hearing today. He refers to the Trump v. U.S. opinion, a 6-3 opinion, by the way, of the United States Supreme Court, as, quote, when the president does it, that means it's not illegal, end quote. I do not believe that that is a fair reading of the opinion. And frankly, I don't understand how anyone who's read the opinion, which I reread this weekend, it's only about 90 or so pages, could reach that conclusion. I know many people look at this opinion, and it is their right. This is America. We can believe what we want. I know many people look at this opinion through the lens of former President Trump and whether they like him or dislike him. The court, in its opinion, was very careful to point out that its opinion, more than anything else, was about the institution of the presidency. The institution of the presidency. The opinion is not just about the litigants in front of the court. It's about future presidents and future Americas. That's point one. Point two. It is inaccurate to say, under Trump v. U.S., that a president of the United States has absolute immunity to do anything that he or she wants. That's just not accurate. For example, the court is very clear in saying that a president does not have criminal immunity, including but not limited to a former president, for unofficial private acts. That's clear. I don't see anybody can argue with that. Number two, the court does say that a president, whoever that president might be, does have absolute immunity for acts performed pursuant to his or her core responsibilities. Responsibilities given exclusively to a president by virtue of the Constitution. But there's a third category, which I would suggest will include most acts by a president. Those are acts taken pursuant to a president's authority, but authority that is also shared with the United States Congress. And the court does not say that a president cannot be prosecuted criminally for those acts. It does not. It does say that if a prosecutor, the prosecution, if it wants to prosecute a former president for that layer or category of acts, the burden of proof is on the prosecutor. Well, duh, the burden of proof is always on the prosecutor. You can call it presumptive immunity, but the burden of proof is always on the state. And the state has to prove that the president's prosecution for that middle layer of acts would not impinge, I think the words would pose no, quote, no danger of intrusion on the authority and function of the executive branch. Now that's hardly absolute immunity. And I'm looking forward to our panel today to enlighten us on this subject. Thank you, Mr. Chairman.
Thanks, Senator Kennedy. Today we welcome 5 witnesses. Our first witness is Philip Lacavara, who formerly served as Deputy Solicitor General of the United States for Criminal and national security cases, counsel to the Watergate Special Prosecutor, and president of the D.C. Bar. We also welcome Mary McCord, Executive Director of the Institute for Constitutional Advocacy and Protection at the prestigious Georgetown University Law Center. McCord was Acting Assistant Attorney General for National Security at the U.S. Department of Justice from 2016 to 2017, and Principal Deputy Assistant Attorney General for National Security from 2014 to 2016. Previously served as an Assistant U.S. Attorney. We're also joined by Dr. Timothy Naftali, a presidential historian and senior research scholar at Columbia. From 2007 to 2011, he directed the Richard Nixon Presidential Library and Museum, where he curated a nationally recognized nonpartisan permanent exhibit on Watergate and oversaw the release of 1.3 million pages of records. Ranking Member Graham, would you introduce the minority witnesses, please?
Thank you, Mr. Chairman. Our witnesses are Professor Jennifer Mascott. Did I get that right? Good. She's a professor and writes and teaches in the area of constitutional law at Catholic University's Columbia School of Law. She's been cited by the Supreme Court and published in the Stanford Law Review, among other publications. She previously served as the Deputy Assistant Attorney General in the Office of Legal Counsel. She was a former law clerk on the Supreme Court and the U.S. Court of Appeals for the D.C. Circuit. Our other witness is well known to this committee, former Attorney General Michael McCasey. He served President Bush in that capacity from 2007 to 9. Prior to serving as Attorney General, he was United States District Court Judge in the Southern District of New York from 1987 to 2006. He served as an Assistant United States Attorney in the Southern District of New York. He works in private practice currently, and he most recently testified before the committee in May 2023 at the Supreme Court ethics hearing. Welcome to both.
After we swear in the witnesses, they'll each have 5 minutes to provide an opening statement. Then each senator has 5 minutes to ask questions. Urge my colleagues to focus their questions on the topics of today's hearing. So we'll start with the witnesses standing to be sworn in, please. You affirm the testimony you're about to give, to believe the truth and the whole truth, nothing but the truth, so help you God.
I do.
Let the record reflect that the witnesses have answered in the affirmative. Thank you, Mr. I want to make sure I pronounce your name correctly. Lacovara?
Exactly, Senator.
Good. You may proceed.
Thank you, Senator, and members of the committee. I want to express my appreciation for the opportunity to appear today, and I want to emphasize at the outset that having served before the Supreme Court for almost 60 years, I have no interest in attacking the court as an institution. Rather, what I'm trying to suggest is that the court, in this decision at least, has brought criticism on itself. The court has always been subject to criticism, sometimes fair and sometimes unfair. It was criticized for the Dred Scott decision, for Plessy against Ferguson, for the Korematsu decision. All of those decisions, I think, have been repudiated by history, although they were rendered by majorities of the court. So the issue is not, is the court above attack on the merits of its decisions? The issue is, as I think you understand, is the decision that's under discussion today one that deserves acquiescence or not? And my submission is that it does not. I explained in my prepared statement that the decision is profoundly wrong and it is profoundly dangerous. It's profoundly wrong for several reasons. Notably, the court did not find any textual support for the decision. Indeed, the text points exactly the opposite. The court could not find an apt precedent in support of the decision. The only reliance the court could come up with, as Senator Graham mentioned, was a decision by a 5-4 court to grant civil immunity from private damage suits. Seems to me pretty obvious to any lawyers, even not constitutional lawyers, that the difference between immunizing a president from prospective liability to private citizens suing about official actions is fundamentally different from immunizing a president from culpability for committing crimes brought for violation of the same public interest statutes that apply to everyone else. The court could not rely on any historical practice in favor of criminal immunity. In fact, the practice is exactly the opposite. I know from my own experience in the Watergate affair that President Nixon was under active criminal investigation for his role in the cover-up. President Clinton was, President Reagan was. At no time before 2024 did any serious lawyer, nor did any of those presidents, claim that there was any kind of immunity from criminal exposure for crimes committed in office, including crimes committed allegedly in the performance of official function. The only issue that was debated during the Nixon period was whether the president could be indicted while still in office. Everyone, including President Nixon and President Ford, in granting a pardon, concluded that the president could be indicted for official acts after he left office. Constitutional text points in that same direction. The impeachment clause says that any person, including the president, whether or not impeached, is liable for indictment, prosecution, and punishment. And that necessarily includes official acts, because the only offenses for which a person, including the president, may be impeached are official acts: bribery, treason, and what are described as other high crimes and misdemeanors. Those were understood when the Constitution was adopted to be maladministration or the improper and possibly criminal performance of official acts. That indeed is what the term bribery means: taking money to perform an official function. Text of the Constitution could not be clearer that a president is subject to indictment, trial, and punishment for that kind of improper, that is, illegal performance of an official function. My statement also goes into detail as to why this is a dangerous decision, not simply an erroneous one. It essentially licenses a president to abuse his power and to get away with it. Nothing could be further from the intent of the framers than to establish the kind of immunity that the king alone, the king who was the target of the abuses identified in the Declaration of Independence. And it seems to me to beggar any sense of the history of our country to treat the President of the United States as having the kind of immunity that no other person in this state, in this country, has to commit crimes and get away with it. Thank you, sir.
Thank you, sir. Professor Mascott.
Good morning, Chairman Durbin, Ranking Member Graham, and members of the committee. Thank you for inviting us here today to testify about presidential immunity and the Supreme Court's consideration this summer of the special counsel's criminal prosecution of President Biden's predecessor and now political rival. As a federal courts and constitutional law professor and former DOJ official, I'm grateful for the opportunity to speak about the opinion in Trump versus United States and help explain its scope. First, it's important to point out that since the court handed down its opinion, a number of public statements and commentary have significantly mischaracterized the opinion's holding and its scope. Some of those overstatements have made their way into some of the prepared testimony before the committee today. And before the Senate can evaluate the merits of the opinion, it's important to discuss what it actually held. So I look forward to summarizing the outlines of the opinion in this opening statement. The justices were compelled to take the case because the special counsel within the Biden administration and DOJ decided to prosecute President Biden's predecessor, and the prosecution has continued into this current political season, where we now have the unprecedented situations of a former president facing prosecution by the DOJ he once supervised, and a sitting president prosecuting his current rival. Second, the Supreme Court opinion actually continued and sustained this matter, remanding it to the lower courts. That remand occurred because the court held the opposite of what many commentators and even witnesses here today said it held. The court held that former presidents can be prosecuted for criminal unofficial acts. Both the former president's lawyers and the government agreed on this point as it relates to unofficial conduct. They simply disagreed about when and to what degree and for what kinds of acts a former president can face criminal prosecution. The court's opinion in Trump versus United States divides the categories of criminal prosecution and acts that are presumptively immune into 3 buckets. The first bucket is unofficial acts that are subject to criminal prosecution. Notably, as my prepared statement points out in more detail, the Office of Legal Counsel within the Clinton administration in 2000 published a formal executive branch opinion suggesting the opposite while a president remains in office. The 2000 Clinton-era opinion concluded that even unofficial acts could not be subject to prosecution while a president remained in office. Rather, a president would have to be impeached and then convicted by this body or have his presidential term otherwise conclude for a prosecutor to indict or charge a president criminally for even official acts under the Clinton-era opinion. That 2000 opinion emphasized the incompatibility between criminal prosecution and potential jury conviction and the role of a sitting president. Importantly, the Clinton-era opinion is clearly based on an underlying doctrine of some kind of extensive presidential immunity. The Supreme Court in Trump versus United States addressed an extension or new application of this longstanding principle of presidential immunity. The court sets out 2 categories of potential immunity. The first represents a category that the court describes as involving core executive functions, and arguably this is a relatively modest subset. It involves functions for which a president historically has been understood to have complete discretion, areas that Congress lacks the power even to regulate, so it's very specialized. The courts list several areas: exercises of the pardon power, discretionary aspects of the removal power, and the power to recognize foreign sovereigns. And these categories do not extend nearly as far as some of the prepared testimony today suggests. The court's talking about the core, inner kernel of presidential authority and decision-making for which the president essentially has complete discretionary power. Decisions such as whom to nominate or fire or whom to pardon. Then there's the middle category that the court describes as extending to the outer perimeter of a president's executive functions. And in this area, the court does not definitively determine whether absolute or presumptive immunity applies. At a minimum, though, the prosecution would have to show an actions manifestly or palpably outside of presidential authority before bringing charges based on that action. And the court left many of the remaining details for the lower courts to work out on remand. Finally, one additional point. The institutional integrity and norms within each of the branches of government has faced repeated threats and challenges. Some are very recent, like attempted violence and the New York Times report of yet another breach of confidentiality outside the longstanding norms of legal practice and service within the Supreme Court. Maintenance of longstanding norms of civility, humility in public service, principle, and integrity necessitates a sober approach to the characterization of governmental actions, and it involves taking a careful, studied look at the actions of fellow governmental servants. Thank you so much, and I look forward to the committee's questions.
Thank you, Professor Mascott. Professor McCord?
Distinguished members of the committee, thank you for inviting me to testify about the potential consequences to government functions of the Supreme Court's decision in Trump v. United States. Like my colleague, my organization at Georgetown Law is a regular litigant before the Supreme Court, and I have respect for the institution of the court. In my government career, I served for nearly 20 years as a federal prosecutor under Republican and Democratic administrations. I served for 3 years at Maine Justice, first as Principal Deputy Assistant Attorney General and later Acting Assistant Attorney General for National Security, and I stayed through transition to the Trump administration before leaving in May of 2017. I agree that a president is immune from criminal prosecution for exercises of core constitutional powers. These include the pardon power, the veto power, and other powers committed to the president by the Constitution or recognized throughout our nation's history. For these exercises of powers, the president's authority is conclusive and preclusive, meaning that Congress may not act upon it, nor may courts examine it. My concern is that the majority's opinion in Trump v. United States capaciously defines core constitutional powers to extend far beyond these well-recognized powers. Concluding that the investigation and prosecution of crimes is a quintessentially executive function, the majority holds that the former president is absolutely immune for alleged conduct involving his discussions with Justice Department officials. That conduct includes the indictment's allegations about efforts to leverage the Justice Department to convince certain states to replace their legitimate electors with fraudulent Trump slate of electors. The majority seems to source this in the Take Care Clause, but that clause says that the president shall take care that the laws be faithfully executed, explicitly recognizing Congress's role. Justice Amy Coney Barrett recognized this, writing separately that Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including through criminal statutes. She would not read the Take Care Clause so expansively. Unfortunately, Justice Barrett's well-reasoned concurring opinion did not command the majority. The potential abuses of official power that are made possible by the court's ruling and the neutering of Congress's ability to act are alarming. Consider first the Department of Justice. Is Congress now disabled from tying the appropriation of funds to certain areas of law enforcement, or from enacting legislation that governs department organization and functions, or from oversight, requesting records and testimony from department and FBI leadership? What would stop a president from directing the investigation of his political enemies, journalists, or activists, even where there is no basis for doing so? The majority said, after all, and I quote, "The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials." Could that sham investigation include directing the FBI to engage in unlawful surveillance, or bypass seeking a warrant to search a home or workplace, or to target individuals or groups based on race or religion? If the president were to bring a civil suit against the Department of Justice, as the former president has provided notice that he intends to do, could he order the department to settle the case for millions of dollars, even if the suit itself were baseless? Moreover, the rationale of the majority's decision would appear to apply to all departments and agencies. No potential criminal prosecution would prevent the president from directing the IRS to launch baseless criminal investigations. Likewise, no potential criminal prosecution would prevent the president from using the CIA for domestic operations. The reforms enacted by Congress in the wake of past abuses would be impotent in the face of a president unconcerned about adhering to the rule of law. Finally, the decision leaves open whether the president's immunity could be extended to subordinates and whether the defendant's limitation on the admission of official acts evidence, even in a prosecution for purely private acts, might be extended to subordinates. But they might not even need that protection if the president promises pardons. This would not only remove an important deterrent to engaging in unlawful abuse of power at the president's direction, it would effectively negate Congress's criminal contempt authority, ending congressional oversight of the executive branch as we know it. I refer the committee to my full statement on the record and look forward to your questions.
Thank you, Professor McCord.